So before we just jump in, high-level update. The LOTA, which is the Landowner Transparency Act, was passed last year, in May 2019. And since then, the LTSA that has the authority to operate the Landowner Transparency Registry has been embarking upon a huge initiative to develop the Landowner Transparency Registry. And what that means is really taking this complex piece of legislation and translating it into technology outcomes. And but not only that, it's really also about developing the appropriate public policies to support the operation of the registry, and to provide these and many other variations of training and various resources for legal professionals so that they can actually start using it, and hopefully we can provide that support on an ongoing basis. And I'm going to pass it back to Shannon, who is then going to take you through a bit more detail into the background and mechanics of LOTA.
All right, thanks, Ruben. So for today, I'll go over the agenda for you. I'll be giving a background, talk about the scheduled timing of LOTA, and give some information about the Landowner Transparency Act. Then Ruben will talk about the registry searches, registry fees, compliance and enforcement function. And then at the end of the session, I'll take you through some sample views of LOTA as well as our website, and then we'll open it up to questions through the chat. So the background of LOTA, it first kind of got brought to the forefront in a 30-point plan for housing affordability that was brought forth by the new NDP government at the time in 2018. And they first hinted at a beneficial ownership registry that could be coming into place in BC. So once it was announced through that summer of 2018 into the fall, they gathered public consultation and feedback. And in June 2018, the province released a white paper and a draft of the Landowner Transparency Act for public review and feedback. So through many readings and consultations in 2019, LOTA, Landowner Transparency Act, received royal assent, and it will be brought into force in the future by regulation. So since that's been announced, the LTSA has been building and operationalizing the Landowner Transparency Registry. So this is the first of its kind in Canada, and there's very few examples around the world that are similar to what is going to be brought into force here in BC. And so it's been a really big undertaking. We've been translating legislation into business processes, writing policies and procedures, training our own staff, training customers, as well as doing internal and external user testing. And most recently in this month, LOTA amendments, Bill 13, received royal assent. So in the LOTA amendments, there was just some tweaking of language around the public search, as well as the introduction of section 17.1, which I'll get into more detail later, but it is a notice to the administrator, and it's when a corporation, a trust, or a partnership ceases to be a reporting body, they'll have to notify the Landowner Transparency Registry. So about the Landowner Transparency Act. So the purpose of this is the Landowner Transparency Act introduces mandatory reporting about indirect ownership of land. So this is ownership interests that are not reflected in the land title register. It will be housed in a searchable public database. So all transferees must disclose if they're a reporting body as defined in LOTA, and that is a relevant corporation, a relevant trust, or relevant partnership. Transferees that are reporting bodies must further disclose identifying information about themselves and about indirect owners of the interest in land. These indirect owners are called interest holders in LOTA. Disclosure obligations are ongoing, so a reporting body must file updated information each time its interest holders change, even though there might not be any change in the legal ownership. Information disclosed under LOTA will be maintained in a searchable database that will be administered by the LTSA, and LOTA filings and searches will have mandatory fees, which Ruben will go over later. So who are the reporting bodies? LOTA describes 3 types of reporting bodies. Each is a legal entity or a relationship that is capable of owning land, and there are distinct and legal beneficial owners. The first, a relevant corporation. So that includes all private corporations and limited liability companies, unless exempt by Schedule 1 or by regulation. And a few of the examples that are exempt, such as in Schedule 1, are strata corporations, government bodies, local governments, and schools. The second type of reporting body is a relevant trust. So all express intentional trusts, unless exempt by Schedule 2 or by regulation. So an exemption example are things like testamentary trusts, charitable trusts, public guardian, and trustee. And as a note there, bare trusts are relevant trusts, so they will have to disclose information to loader. And the third type of reporting body is a relevant partnership. So this includes all partnerships unless they're exempt by regulation at a later date. This brings us to interest holders of the reporting body. So for each type of reporting body, there's a type of interest holder. So for a relevant trust, the interest holder is a beneficial owner. So this is someone who has a beneficial interest in the land, has a power to revoke the trust and receive the interest in land, a corporate interest holder of a corporation that has beneficial interest in the land or the power to revoke the trust and receive the interest in the land. For the relevant corporation, the interest holder is the corporate interest holder. So this is someone who owns or controls, along with others, directly or indirectly, 10% of the equity, typically shares or voting rights. They also have the right to directly or indirectly appoint or remove a majority of the directors. The third type of interest holder is a partnership interest holder, which is under the relevant partnership. And this includes a partner of the relevant partnership, a corporate interest holder of a corporation who is a partner in a relevant partnership. And through the regulation, there may be prescribed interests that are added to these in the future. So there are 4 plus prescribed rights types of interests that require a disclosure to the Landowner Transparency Registry through the Landowner Transparency Act. The first type is an estate in fee simple ownership. The second is a life estate. The third is the right to occupy the land under a lease, with the term of the lease being more than 10 years. And 4, the right to occupy or require transfer under agreement for sale. And again, any kind of prescribed right that comes through the regulations. And a good rule of thumb for knowing when a Landowner Transparency Registry disclosure is required is that when there's an example of a PTT being required, generally a loader disclosure would be required as well. And under Section 6, there are some exempt lands that do not have to disclose under LOTA into the registry. And those are the treaty lands, the recognized self-governing First Nation lands, including Sechelt, Niska, Manluth, and Tla'amin. And also exempt are the reserve lands and any prescribed lands in the future. So when are LOTA disclosures required? The first event is on registration. So this is on application to register legal title in land. And that prompts a 2-tiered obligation. So each transferee in the legal interest in land must file a transparency declaration indicating if they are a reporting body or not. And if they are a reporting body, they have to say which kind of reporting body they are. So either a relevant corporation, a relevant trust, or a relevant partnership. If they are one of those 3 types of reporting bodies, they also have to file a transparency report. And so that is a secondary document which discloses specified information about each interest holder. The second triggering event for when LOTA disclosures are required are for pre-existing owners. So when LOTA and loader come into force, reporting bodies that currently own an interest in land will have to file a transparency report if they are a reporting body. This is a one-time obligation. The third triggering event is a change in interest holders. So each time the interest holders in a reporting body change, the reporting body must file an updated transparency report. So again, there may not be a legal change on title, but just in the interest holders of the reporting body. And the fourth triggering event, which was passed in the Bill 13, the amendments, is Section 17.1. So registered owner ceases to be a reporting body. So there must be a notice to the loader administrator given if a corporation, trust, or partnership ceases to be a relevant corporation, trust, or partnership. So an example of that may be that they may be changed to a type that is now exempt under Schedule 1 or 2. And a note here is that reporting bodies may also choose to file a new transparency report at any other time if they need to complete or correct information that they had previously given. And now I will pass it to Ruben.
Thanks, Shannon. So following upon the triggering events, we now get into the really the manner of the filing and the role of the registrar, which is critical in the filings as described in the Act. So the manner in which transparency declarations and transparency reports are filed is they're filed with the loader administrator by way of submission to the Registrar of Land Titles. So the submission is always to the Registrar of Land Titles, and then it gets filed with the loader administrator. So everything comes in through the door, through to the registrar first. So since submission is by the Land Title Office or the Land Title System, Land Title Act filing provisions apply, which is Part 10.1. So that's anything with respect to e-filing, as well as manual or paper filings, in which case a registrar can certainly accept under certain circumstances. So all of those provisions will apply because the role of the registrar is there. So where loaded documents are submitted with an application to register an interest in land, they must be submitted together with the land title application. So what this means really is, for example, you have prepared your Form A application. You have also prepared your PTT, and now you have your transparency declaration, and potentially, if it's a reporting body, your transparency report. So all of that is prepared, and the entire package is then submitted at the same time. If, in the case where a transparency declaration is not accompanied with a land title application, for electronic filing, the system is designed so that it will not accept that submission. So it will remind you that you need to submit a transparency declaration or a report or a report. And that's going to be the same case if filings are done manually or by paper, either mailed to us or across the counter. All of these requirements must be met. The only time, and I'll actually get into this a little bit more, the only time where a land title application can come in through without a transparency declaration is in the case where, as Shannon covered, Section 6 exempted lands, so indigenous lands are not covered. So yes, the registrar can accept the application without loader disclosures. So as I've mentioned, the registrar is required under the law to refuse an application to register in land if it's not accompanied by loader filings. So transparency declaration in all cases except Section 6 lands, where you're basically excluded from LODA, so you can that can actually come through without the loader disclosures. And then transparency declaration and transparency report in all cases if the transparency declaration indicates that the transferee is a reporting body. That is the automatic trigger that you need to file a transparency report. So continuing on with manner of filing. So the registrar's role is very limited to exactly what I just covered. So in that, just to ensure that the land title application has the right accompanying loader filings when required. And of course, the fees. Now, the registrar is not obligated to look into the veracity of the loader filings to check the accuracy or the content of those filings. So once those requirements, as I've covered, are met, it is essentially submitted through to the registrar and then filed with the loader administrator. So registrars effectively, in addition to making sure the package is all right, registrars to ensure that it is certified, signed, and submitted in accordance with LODA. So what does certification mean? So certification is a specific definition within LODA. And so certification is really a confirmation that the transparency declaration and or the transparency report is correct and complete. Now, who does the certification? This is really the person who has the knowledge and facts contained in the document, the disclosures, and the authority to sign on behalf of the transferee or the reporting body. So that's the certifier in LODA. And then in terms of signature, really, as far as the electronic filing is concerned, signature is really the electronic signature of the subscriber or the juror cert applied, just to ensure that that has been incorporated into the electronic filing, and it has been certified before. And now, one of the requirements will be the subscriber to confirm that the true copy of the document has been certified before applying the signature, which is consistent in the other applications as well. Manual declarations, as I've mentioned, if the registrar accepts, which is paper filings, must be wet ink signed. And then submission is really, as I've described it, is really the manner in which they're submitted to the registrar and then filed with the LODA administrator. So let's get into, we've talked a lot about transparency declarations and transparency reports. Let's really get into now what is in these reports. So what we've done here is we've tried our best to really create a bit of a checklist for you. It's really a summation of what is exactly prescribed within the Act. And we've basically attempted to try and provide you with as much information as to what needs to be provided. So there's 6 categories of information in a transparency report. And the first is the requirement to disclose information about the reporting body. So, and the information that you're going to be disclosing is what is called in LODA and defined in the Act as primary identification information. And these are actually captured very specifically under sections 7, 8, and 9, depending on the entity. And so in the case where the entity is a reporting body, but it's an individual, so a trustee, for example, the information that would be required to be disclosed is as shown in this slide here, for example, full name, citizenship, or permanent residence, city and province, country of residence, if in Canada or not, and incorporation number and jurisdiction. So similarly, if it's a corporation or a limited liability company, there's specific prescribed information that must be disclosed. And that's, again, as I mentioned, the to section 7, 8, or 9, depending on the entity. And there you will see for partnerships, that is the type of information that will need to be disclosed within the transparency report. Then the next category, we're really kind of drilling down from the transparency, from the reporting body down to the interest holder. So next set of information is about the interest holder. Here we're getting into more sensitive information, which is date of birth, address, social insurance number, tax number, or ITN if it's available, individual tax number, and residence for tax purposes, and then of course a description of the interest that's being held in the reporting body. There's also a requirement to disclose specific information in relation to the reporting body. And so those are items like business number and corporation number. If it's a trust, then it's information about the settlor land title act trust instrument number if it's available. And in the case of a partnership, there's information that needs to be disclosed about the type of partnership. And of course, the parcel identifier, as you're very familiar with, in relation to which the report relates to. And then finally, the certifier's information, which is the name of the certifier, contact information of the person signing the report. And as always, there's within legislation, there's prescribed information or if the province decides to add any further information for the future. So we do get a lot of questions about this in terms of, what level of due diligence is required in the preparation of a report. So the legislation, LODA, does provide some guidance on this, but not in too great of a detail. But really what the legislation requires is that the role of the reporting bodies is to take reasonable steps to obtain, confirm the accuracy of all the required information within a transparency report. There is also a reciprocal obligation by interest holders, on the part of interest holders, to provide the requested information accurately. There is some language there that it's an offense to not comply, and that falls under the under the enforcement officer's authority to enforce those components of providing information. Now, in the event that a reporting body is unable to obtain all of the required information, then the reporting body actually has the ability to be able to explain, here's the summary of information that I've been able to obtain, and here's all the steps that I've actually taken to obtain this. So it's really about providing some rationale, and that's, again, a requirement within the Act. Because it's not going to stop you from filing the report, you still can, because in some cases you may not be able to obtain all that information. Then there's also a requirement for a reporting body to disclose that if a reporting body becomes aware that an interest holder may be incapable of managing their affairs, the reporting body must take reasonable steps to determine if this is so. And if this is so, there is a section within the transparency report where you can indicate that that the individual has been incapacitated. And so before filing the transparency report, there is an obligation under Section 24 of LODA that the reporting body take reasonable steps to notify interest holders certain key pieces of information. And that's Section 24. So some of that, actually, the key notifications are that the information about the interest holder is being collected and disclosed under LODA, that's a requirement. The next one is that to notify the interest holder that the individual has the right under Section 40 of LODA to make an application to omit information from the registry if their health or safety may be at risk due to publicly searchable information. So really advising them that they can make that application. And then last but not least, that unless the individual makes an application to omit information, that all of the information, excluding the confidential information such as SIN and date of birth, will be available for public search within 90 days of filing. So there's some requirements of notification before filing the transparency report. So that brings us to search, quality control, and various applications. So as I mentioned earlier, when LODA moves into force, search will likely come into force sometime in early 2021. So there's still time yet before the public and or any other entities are able to search. So first of all, the public can only search a limited subset of information in LODA, what is deemed to be publicly accessible information. So the only information that the public can have access to is primary identification information. So they have no access to date of birth, SIN, etc. So the manner in search is very specific, and search is really covered under sections 30 and 35. Section 35 of the Act specifically sets out how you can conduct your search as a member of the public. And so that one search is by way of searching by parcel identifier to get information about the reporting bodies, primary identification information about reporting bodies, interest holders, or settlors. The other way that they can search under Section 35 is by way of a name, in which case name of a reporting body, an interest holder, or a settlor, in which case you would obtain information about the interest in land held by the reporting bodies, the interest holders, or the settlors. So there are only 5 entities under LODA that are authorized to have access to what is called complete transparency records. Transparency records include the transparency declaration and transparency report information. So, and those entities are specifically prescribed within Section 28 of the Act. So, for example, in this case, one is obviously the enforcement officer, and I'll cover off the role of the enforcement officer in the subsequent slide. The Ministry of Finance employees, taxing authorities. This includes Canada Revenue Agency and BC Assessment Authority, and then law enforcement. So in this case, this includes any officer covered under the Police Act and the RCMP. Regulators, these are specifically contained in Section 28 of the Act. So that's BC Securities Commission, BCFSA, which is now FICOM, Financial Institutions Commission, which is now the BCFSA, FinTrack, and the Law Society. So those are the entities covered under regulators currently in LODA, and those are the entities that I've mentioned here that have access to the full transparency records. Okay, so there's several applications. I've mentioned one already, and that's the first one there is under Section 40 of LODA, which is an application to omit if health or safety at risk. So a person under LODA may make an application to the LODA administrator to have their primary identification information removed from public search on reasonable belief that there may be a threat to the safety of themselves or to a member of their household. And so there are certain requirements to make this application. One is, of course, to provide some evidence to support the application, including the grounds. And then the LODA administrator under the Act may also require further supporting documents or records in support of their application. On making that initial application, if we're able to match that information in the registry, if the requisite information provides us enough information that we can identify the individual and the PIDs, we are required to omit that information immediately, pending review and determination. The next application is a Section 42 application to correct or change. So a person, an individual, may apply to request that certain corrections be made to a transparency report that's already been filed, or information correction or change of information in relation to publicly accessible information. And this could be for the purposes of correcting information on a previously filed transparency report, or to correct inaccurate information, or to even complete some information because a previously filed transparency report didn't have all the complete information. So that's the provision. And it's pretty similar, the requirements, except that the individual must first make the request to the reporting body to revise or correct that information. Now, only if after 90 days, the reporting body has not made that change, the individual can then make this application under Section 42 to the administrator to initiate the change. And again, requirements are to provide evidence and support, grounds for the change. And again, if there's lack of or insufficient information, the administrator may require supporting information, further supporting information. So LODA does provide some broad authority for both the administrator and the enforcement officer to make changes. So the first will cover LODA administrator. On the administrator's own initiative, the administrator may omit or obscure information from public accessibility if it considers that there may be a risk to the health or safety of an individual. So there's a bit of a broad authority to do that on their own initiative. The administrator may also annotate a filed record, however, in a manner that does not conceal the original content of the transparency report. And then certainly the administrator can make changes to reported or publicly accessible information as well. In regards to the enforcement officer, so upon conclusion of an inspection, if the enforcement officer has determined that certain file information is either incomplete or inaccurate, they can certainly direct the administrator, myself, to omit and obscure information, to annotate a file transparency report, or to make changes to reported or publicly accessible information. So fees. LTSA fees are set by the board of directors, and these fees are currently published in both the LTSA website and the LODA website, landtransparency.ca. So for filing a transparency declaration, it's $5. Transparency reports are $35. And inspection and searches by both the public and other entities like regulators and law enforcement is $5 per search. And the application section for application to omit is $30, and any application to correct or change information, that's $150. And again, as mentioned, fees are always paid at the time and in the manner required by the administrator. So when you file, the fees must be paid. The only fee that is actually not showing here is the one that, as Shannon covered, the new section 17.1, which was contained in the recent amendment, notice to the administrator. So that fee is not here, and the reason is because that amendment to LODA just received royal assent a couple of weeks ago. So we will have to take this to the board of directors to set fees and publish those fees. Compliance and enforcement. We've talked a lot about enforcement. And I want to be really clear on this, and there tends to be some confusion with sort of our role as LTSA and my role as the administrator. The role of compliance and enforcement is solely a government function. There is no authority for LTSA nor myself as the administrator to take on the role of compliance and enforcement. There's no authority within LODA by the administrator to do that function. So basically, the Ministry of Finance may designate an enforcement officer to be responsible for the general enforcement of the Act and regulations. At a high level, the enforcement officer's duty include conducting inspections, including obtaining warrants, searching premises. LTSA nor the administrator have none of those authorities. The enforcement officer has authority to make rulings or determinations related to compliance, and also authority to issue penalties. That includes also there's various administrative infractions and penalties that are articulated in the Act as well. The appointment of an enforcement officer is not mandatory. At this time, we are not aware as to who is going to be taking on that role within the province, and I'm not sure when that role is going to be in place. Okay. So I'm passing this back to Shannon. She's going to cover some information around loader itself, the system. Shannon?
Yeah, thanks, Ruben. So this is an example of what the landowner transparency registry will look like. And if you're used to using my LTSA, it might look a little bit familiar to you. So in the middle there, we have active and submitted tabs. And as you can see underneath the loader ID number, it says number TD, and underneath two nesting reports TR. And the TD is the transparency declaration for a property, and the two TRs are transparency reports of the transferees who are reporting body. So first I'll just take you through what a transparency declaration looks like. So you would hit this button to make a transparency declaration, and that is done for every single transfer, regardless of if the transferee is a reporting body or not. And it will take you to a page that looks like this. So on the left-hand side, you can see there's create record and property information, transferees, certifier information, validation, and presentation copy, and e-sign. So as you work through each section, it will take you through all of those different categories to input information into. And after you do that, it will take you to a validation page. So because there was no information inputted into this transparency declaration, you can see that all the information is missing. And in order to e-sign the copy, you will need to ensure that all of the red errors are missing or have information inputted into them. And it will allow you to e-sign and submit to loader. The other document is a transparency report. And as we mentioned before, you might just create a standalone transparency report when loader is brought into force. And that would be just to say that a property who is owned by a reporting body, you would need to submit a transparency report to the loader so that that information was on file. Again, it looks similar to what the transparency declaration looks like, except for there is more information involved. So you would have to go through all the categories on the left-hand side, again, pass the validation before you can e-sign and submit. And some of these questions will change depending on what information is selected. So at the top there, you can see it says what type of reporting body is a transferee, and depending on if it's a relevant corporation, relevant trust, or relevant partnership, the information below will change. Again, there's at the bottom middle there, it says, does this corporation have a head office? Depending on if you select yes or no, the information will need to be inputted. And that goes through like that for the entire form. And this is just a quick screenshot of what our website looks like. So that if you go to landtransparency.ca, there's a lot of great information on there, including links to the legislation, as well as frequently asked questions, etc. So at the top there are different categories: filing, accessing, enforcement, and about. And depending on what you click, you can get information from each of those categories. So for example, the filing requirements are put on there. And on the right-hand side, you can see there's a link to the legislation. And importantly, at the bottom of every page, if you scroll to the bottom on landtransparency.ca, there's an input for you to put your email address. And so if you sign up for a newsletter, you can stay informed and get reminded of key filing dates as they come up.